I have made a finding that the elections for the member of County Assembly for West Kanyamkago Ward were conducted largely in accordance with the Constitution and the relevant electoral laws. There is therefore no basis for invalidating the election. And the last issue is, what order does the court make with respect to cost? Section 84 of the Elections Act provides as follows: an election court shall award cost of an incidental to a petition, and such cost shall follow the cost. Rule 30 of the Elections, Parliamentary and County Elections Petition Rules 2017 provides as follows: the election court may, at the conclusion of a petition, make an order specifying the total amount of cost payable, the maximum amount of cost payable, the person who shall pay the cost under paragraph A and B, and the person to whom the cost payable under paragraph A and B shall be paid. I have considered the nature of the petition, the issues involved. I am aware that the advocates for the petition and for the respondents traveled from Nairobi in all the occasions they were required to appear before court. The petition having been dismissed, the first, second, and third respondents shall be paid costs by the petitioner. Cost for the first respondent shall not exceed a sum of Kenya shillings 700,000, while cost for the second and third respondents shall equally not exceed 700,000. The cost shall, however, be taxed. The security for cost deposited in court shall remain so deposited pending taxation, and the cost as taxed shall be paid out to the security deposits on a pro rata basis. Conclusion. In conclusion, I find that the allegations that the election was not conducted in accordance with the Constitution and the election laws have not been proved. The irregularities and errors established were not of the kind that would impeach the election of the first respondent. I accordingly find that the first respondent was validly elected as a member of the County Assembly for West Kanyamkago Ward. A certificate of the court as to the validity of the election will pass on to Section 86 of the Elections Act, issued to the second respondent and the Speaker of the Migori County Assembly forthwith. Lastly, I wish to thank the advocates for the petitioner and the respondents for their diligence and for presenting their respective briefs in an orderly manner, and for assisting the court with the statutory and case law.
I want to thank God for He has been with me all along. The truth is that when we went for elections, and this is something that I have to speak, we conducted our elections free and fair. During party primaries, I authoritatively want to retaliate that I won during our party primaries. I was denied that ODM ticket. Then the people of West Kanyamkago urged me to go and look for an independent ticket, of which I did. I came, I did my campaigns peacefully, and we won the elections. So I want to appreciate the people of West Kanyamkago for what they have done and the confidence that they have always bestowed in me. As we speak, this court process has really delayed some of my plans in the ward, and I would really request that let it rest where it is today, now that the court has upheld my re-elections, so that we start working for the people of West Kanyamkago. Thank you.